Welcome to the third season of PrivacyCast. In this podcast series, we bring together some of the most insightful minds in the field of data privacy to discuss the latest developments in the field and trends of digital privacy lives. Whether it's a new threat online to what is the new laws incoming, what are the new case scenarios that we have to think about, everything is here in PrivacyCast. And here we are today again with one of our speakers for a session called The Importance of Consent under the Digital Personal Data Protection Bill, the DPDPB bill in India. My name is Akarsh Singh. I am your host of PrivacyCast. Also, I am CIPPE, CIPM, CIPD fellow in information privacy, and also one of the youngest people in IIPP's Asia Advisory Boards. So a little bit about myself. Today's session, we want to talk about importance of consent under DPDPB. In India, we'll cover the history and evolution of consent, specific requirements for obtaining consent that are upcoming, exceptions to consent, and the rights to withdraw the consent. So today's session will a lot be focused on consent in the upcoming Indian market, in the upcoming Indian law. What is going to happen with data fiduciaries? Let's just go together with none other than a fellow privacy enthusiast and also a partner at AZB and Partners. Mr. Aman Gera here is with us. He's a partner with the law firm and he's one of the most notable lawyers achievements under his name. And he's here with us. Handing it over to Mr. Aman for a short introduction. Sir.
Hi guys, thanks for having me. Really appreciate it, and I've been looking forward to our discussion. Let's jump straight into it.
Yeah, perfect. So, first question to you is, what is privacy to you? What's the first thing that comes to your mind when somebody says privacy?
Personally, I believe privacy is different for different people. Right? Talk about real life examples. How I want to use social media can define what I think about privacy, and you don't test everyone by the same standards. People can have different thoughts. Somebody may be okay to share something, someone may not. So the privacy definition really changes. I think what's important is that everyone should be taking conscious decisions. We should all know, what am I giving? What am I giving it for? Can it be used for anything other than that?
So privacy, right to privacy, right to conscious decisions on your data is privacy. I think that's a great answer. I think we will definitely keep this answer. I know people will love hearing this, and I same thoughts, right? Same thoughts. But moving on, right? What do you think about this consent requirement? Everybody's talking about it since Digital Personal Data Protection Bill is there, right? Since the Indian law evolves around or revolves around consent. So what are these requirements, right? What are these provisions, that are up and coming?
Consent is nothing new. Of course, it's there in the 2022 DPDP bill. Even our existing law, which is in place since 2011, it talks about consent. It talks about consent in a limited way. There is sensitive personal data under the existing law, and you need consent if you want to collect and use sensitive personal data. What the DPDP bill is doing is it's going a step ahead. It's talking about consent for all kinds of personal data, not just sensitive personal data, which is the case under existing law. Sensitive personal data under existing laws, things like your bank account information, your financial information, health records, passwords, and so on and so forth. Only for these kinds of information under the existing law do you need consent. This is going to change when the new law kicks in. The new law talks about, irrespective of the kind of data, the personal data or sensitive personal data, you need consent, which means you need to tell people what you are collecting, and you need to tell those people how will you be using that information. When I say people, I mean individuals like you and me, like anyone who's listening to this podcast. It does not cover corporate organizations. So it's only individual personal data for which these requirements are going to apply.
Right. So now when we say that, it is for the corporates or, as an organization, let's say Amazon's, right? Amazon's e-commerce, right? So then consent becomes a basis till somebody has bought something, because when somebody has bought something, then, the basis may also change to contract, because initially when you are on the platform, it's consent, people are giving you recommendations, like if you're on Myntra or anyone, right? Any online platform, that suggestion that comes, that pops up, you may like this shirt also, right? So you're saying that consent process, will kind of help us decide more over there.
I think businesses change and businesses evolve over time, right? So to determine whether we can have a broad consent language today that will encompass all future use cases, it's very difficult. So the idea of, I think, consent, and for a consent to be valid, is now there needs to be some sort of specificity, right? What are you going to be using that information for? It could be multiple purposes. I'm not saying that it should only be for one purpose, which is like your primary purpose. It could be for other things. It could be for advertisements. It could be for collecting your information and passing it to others who may think that you are relevant customers for their services. But I need to have that clarity, or I need to give that clarity to my customers. And when I say I mean any entity which is collecting personal data. We need to give that clarity to our customers, to our users, about what is it that the information is going to be used for. And if we think that, there is any new use case which is not compatible with what I had told earlier, or there is a new use case which I didn't mention in my notice or my privacy policy. If I want to use that information for that new purpose, I should inform the customers before the information is used for that new
Purpose limitation, purpose mapping to consent is very important now, right? Earlier, it may happen that you're using for a few more purposes, but it may not work anymore for organizations. If consent has been taken, purpose has been mapped, data can be processed. Is it okay? Is that where we are going?
I think that's a very interesting point you raised there, Akarsh. Even our existing law, to some extent, talks about collection limitation, purpose limitation, storage limitation. These principles exist even today. It's just that they are being further strengthened. To give you a couple of examples, like one of the things that we'll see in the new law is that if any information is not required for a particular service, then you can't mandate giving that information. So, for example, if an app in my phone is not required for me to use that app, or if a permission is not required by an app in my phone to function, then it can't be compulsory for me to give that permission. That's point number one. And I think point number two, in today's day, you see a lot of these privacy policies being very, very widely worded, right? They'll say things like, I will do it to improve my services, I will do it to improve my products, and so on and so forth. And these are very commonplace, this is very, very common language across multiple websites. To my mind, with the requirement of consent and where we are heading, the days of these widely worded consent languages, they are going to be over. For a consent to be valid, there needs to be some sort of specificity. And in fact, if you look at the provisions which talk about consent and which talk about what are the requirements of a valid consent, you will see there that the consent needs to be informed. It needs to be meaningful. And how do you make it informed? How do you make it meaningful? By telling exactly what you are collecting and how you are going to be using it, giving the customers a real choice to control how their data is used.
So basically, consent cannot be conditional. It has to be informed. It has to be meaningful. It has to be mapped to purpose. It has to be taken, right? But I want to ask you then what is this? We're talking about this, but what is this deemed consent? There's also a concept of deemed consent, right? Do you think then an action will be taken, or do you think that is actionless?
I think deemed consent is to basically carve out certain exceptions for which consent may not be the correct basis of processing, or there could be a processing without obtaining consent. To give you an example of employers, right? Entities, we have employees. Now, there is a enablement under the DPDPB bill that for the purposes of employment, such as hiring, such as performance evaluation, enforcing the attendance, taking consent for these purposes could be cumbersome or could not be required, or may require disproportionate effort on part of the employer. So these kind of things have been carved out. This is where we are calling there is a deemed consent. Personally, to my mind, I think deemed consent can be somewhat misleading. And why I say that is deemed consent implies that there is a consent which can be withdrawn. Right? These are rather purposes for which consent is not required. And which means if consent is not required, then there is no question of withdrawal of consent. But when I talk about deemed consent, it gives me an impression that I could even withdraw a deemed consent. Of course, there are other instances or other grounds also for which deemed consent exists. So things like, in a mergers and acquisitions transaction, any information is publicly available, credit scoring. These are some grounds, and there are more as well. If the state government to do a function under law, so if someone has to issue you a license, there is a deemed consent for that. And there could be more such consents or situations in which consent is not required. More of them could be prescribed by the central government in the future.
We also have been talking about consent, and we just talked about government is going to come out with provisions. But my question is government going to come out with it, or is there some authority that we're talking about, which is the new authority that India is setting up, right? Which is a court, right? So, and being a lawyer and being a senior person taking care of privacy, I think who better than you to ask this, right? How is this data protection authority, gonna work? And when if somebody has to do a case, or where is it gonna happen? Someone, tell us.
Yeah. So under the 2022 bill, there is a data protection board which is going to be set up. The previous versions of this law, and this is the fourth iteration of the privacy bill. We had 3 versions preceding this one. There was a concept of a data protection authority. So anyway, if there is a grievance today, or once the new bill comes into play, there is an obligation on these entities to have some sort of officers to address these grievances. There are normal data fiduciaries. So these entities or these companies which collect data, they are called data fiduciaries under the new bill. They have an obligation to have an officer if you are a significant data fiduciary, which means if you are a big data fiduciary, you are classified as a significant data fiduciary under the law, then you need to have a data protection officer. And these are the people who are responsible for handling grievances or complaints of the users whose information is being collected. They are the persons who are responsible for ensuring that these requirements are met, the bill is followed, the customer grievances are addressed, and so on and so forth. In fact, it's not a concept which is unique to the new law. Even our existing law requires details of a grievance officer to be mentioned on the website. So you will see a lot of privacy policies have details of grievance officers even as on date before the new privacy law has kicked in. And that's because of a direct requirement to this effect coming from our existing law.
I feel like, and we were just talking that it's not, for Indians, it's not new. IT Act has been there. The principles of privacy, like purpose limitation, consent, have been there. But what is the major difference today, or maybe 3 months later, 6 months later, 1 year, whatever, right? 6 months later. Let's take an example, 6-month monsoon, right? And compared to 6 years before, similar provisions, but because there will be a penalty, right? So people's thought changes, right? So GDPR, when it came in, the enforcement happened through penalties. And then when penalties came in, so penalties when they come in are not just penalties, right? They're also like a brand issue. And nothing tarnishes the brand more than not having customers trust and not being able to perform as the customer wants us to perform. So I think it's beautiful looking at how privacy becomes enabled in an organization indirectly, right? Reversely, because a customer wants it. So slowly the organization wants it, and then it goes to the top and everybody works on it. But I think moving on, what are these exceptions? I think we talked a lot about consent today, and it's obviously our session today is focusing on the consent. So what are these exceptions to consent, Aman, right? In our provisions in the current draft fourth version, right? What are the exceptions to consent?
And so there are that's interesting. So leaving consent apart, there are specific and separate exemptions also, which this version of the law is talking about. So to give you some examples, if there is some processing that needs to happen in compliance of a judicial function, or some processing that needs to happen for investigation, prevention, prosecution for an offense, or you are a person sitting in India, you are processing some information of individuals sitting outside India on the basis of a contract that you, the entity in India, has with an entity outside India. These are some cases where consent or there are some exemptions under the Act from a lot of the provisions. But even when you are processing information, personal data for these purposes, you still need to safeguard the information reasonably. So it's not like nothing applies. Most of the provisions, of course, you get an exemption, but you still need to be reasonable in your processing activities. Apart from that, of course, there is an enablement that central government may exempt instrumentalities of state, for reasons like interest of India, friendly relations of states, for archival and statistical purposes also, central government may exempt data processing. There is one very interesting separate exemption also, which is that some entities may be exempt from certain provisions of the bill. What are these provisions? Provisions that apply to significant data fiduciaries. Provisions that say that notice needs to be given. Provisions which say that data needs to be deleted. Now, under the previous iterations of this law, from 18, 19, 21 to 22, a similar exemption was also contemplated, but that was more specifically in case of small entities or small entities doing non-automated processing. This version of the bill is silent on whether this is for small entities, is this for non-automated processing, is this for your Kirana stores? We'll find out, I guess, but we've seen similar provisions in previous versions, but in a slightly more, they give an indication who they will apply, who is it relevant for, which we don't find under the wordings of the present bill.
Yeah.
We'll find out.
So, I think talking to you a lot about consent today, being a focus of consent, what are these ways that we can take consent? Can you give us some examples?
Right. So, let me go from where we are to how we are going to where we are progressing. And so, under the existing law, the law only tells you 4 or 5 things that you need to cover, but there's no guidance on how to cover it, right? If you remember the whole Facebook incident that happened at a congressional hearing, Mark Zuckerberg was asked, and one of the senators held this bigger a contract in his hand, and he was asked whether anyone goes through this bigger consent form, and Mark Zuckerberg's answer was no. And in fact, interestingly, that senator happened to be a lawyer, and he said, even I don't understand. So the important thing is how you take consent. You make them smaller, you make them easier, you adopt a more customer-friendly or customized approach. We could be looking at a scenario where consent forms are prescribed, where the government tells you exactly how consent is to be taken, but that is not a given right now, and we'll find out more as we get there. To give you examples of how you can make it easier, how you can make it more interesting, and for your customers to understand, look at the approaches some of these bigger companies are now taking. If you look at Meta's privacy policy right now, you will see it's divided into multiple sections. Each section has interesting videos which tell you what they are collecting, how they are using your data. They give you umpteen examples as well. Twitter is another example. Twitter in the very beginning talks about, we want to give it to you in a tweet. Unfortunately, we are unable to do it for different reasons. In fact, they have a game. If you scroll down the Twitter privacy policy, they have a Twitter Dash game which they encourage you to play. And as you play that game, you learn about how Twitter collects your information, what are its policies, and so on and so forth. I guess entities need to introspect. What are they collecting? How are they using it? What are the market services?
Yeah.
Do I need that information for, for my purpose? And think about how these things can be made, how consents or privacy notices can be made.
Yeah, and I think that's great pointers for all of us, right? I think people who are listening to this, our audience, I know would have loved this already. And I just want to thank you and the audience, for being with us till here. And as we wrap up the episode of PrivacyCast Season 3, we hope that our discussions have provided you valuable insights to concepts of consent as it exists in the draft data protection bill. We've explored the evolution of consent requirements and the DPDPB, discussed something about data fiduciaries and how consent will work. But there's a lot to be there. There's a lot to be. Subscribe to the channel. Incoming is the next episode after this, and we will come with even a better episode for you. So stay in touch, subscribe to the YouTube channel, and we will come back to you with a better episode. And guys, thank you for being with us today. And thanks a lot. And